Ethical Perspectives on the News is produced by the Interreligious Council of Linn County, which is solely responsible for its content. The views and opinions expressed on this program do not necessarily reflect those of the staff and management of KCRG TV9.
Good day and welcome to Ethical Perspectives on the News. My name is Linn Tabalk. I will moderate our discussion today. Our topic is the role of the Supreme Court. Now, to help us explore this issue, we have three guests. Two are professors of law at the University of Iowa, and one is a professor of political science. And you may be familiar with some of these people as they've appeared on this program and others talking on topics like this. So let me introduce them briefly and ask them to say a few words about themselves. Andy Grewal is a professor of law at the University of Iowa and has been there for most of a decade and has some practice in has been practicing law in addition to his academic career as well, right? And Tim Hagle is professor of political science at the university, and Professor Pettis, Todd Pettis, is another professor of law at the university. So let me ask you to say a few more words about your special interests and whatever you'd like to tell our audience about yourselves as we begin this discussion. Andy, you want to go first here?
Sure. Thank you for having me on the show. As Leon pointed out, I've been here for about 10 years, and Iowa is my new home. I'm originally from California, but I have no interest in going back. I love the Midwest charm. I'm looking forward to talking about the Supreme Court with you all.
Okay. And Todd, you're our other professor of law, so maybe you'd be a good follow-on there. Tell us about your background and interests.
Yeah, I came to Iowa City in 1999 for the job to teach here at the law school. I've been on this show from time to time for maybe a dozen years now or so, and I always enjoy it. So thanks for having me back.
Very good. Thank you for joining us. And Tim, professor of political science, and I think you're also getting calls from the media to comment on elections and so on. Is that right?
I do. I've been on this show before. It's good to be with you again. Yeah, I do a lot of commentary and analysis on elections and so forth, although my main area of research interest and teaching is judicial politics and behavior with a focus on the U.S. Supreme Court, and I'm also an attorney.
Oh, okay. I didn't. Very good. All right. So let's begin with just laying a foundation with some facts about the Supreme Court. I brought one little show and tell to get our topic started. So here is a copy of the Constitution and the Declaration of Independence in a very thin book. So the Constitution doesn't have a lot of text that describes the role of the Supreme Court. Maybe you can tell us a little bit about where we start there at the very beginning of our country's history. What is the basic framework for this institution? Anybody want to tell us anything there?
Yeah, as we know, the Constitution, the first three articles lay out the basic structure of government. First and foremost, we have a Congress. In the second article, we have a president. And listed third, the so-called least dangerous branch, is the Supreme Court and lower courts as Congress establishes. So arguably, the Constitution makes Congress the most important by listing Congress first. And it's often referred to the courts as being perhaps, because it's not politically accountable, the least dangerous branch.
Very good. Okay. Anybody else want to say something about that before we? So there are 9 justices, and I looked at the Constitution and I saw the phrase that they serve during good behavior. What does that mean?
Well, it means they have jobs for life unless they behave badly enough to get themselves impeached or unless they choose to step down. But under our Constitution now, they're lifetime appointments.
Okay. Has this ever been controversial? Has there ever been any concern about elderly or infirmed or justices?
There actually has been that initially, well, actually with regard to impeachment, and the early on, there seemed to be an attempt to try to make it a political way to get rid of justices from the court, and that didn't seem to work. As the other professors are probably aware, Samuel Chase was impeached, and he was apparently a fairly nasty person and very political by our standards, but he wasn't removed. But because of life tenure and illness and a lack of retirement benefits and so forth, there were problems that a lot of the justices actually were too sick to perform their duties. And of course, in the 1800s, they had to physically ride circuit to go out to the various places and serve on the courts of appeals. And so eventually Congress passed a pretty good retirement package with the goal of having some of the justices retire, which they did, and new justices were then appointed.
So I was curious, does Congress have any ability to move judges around within the system? Is this appointment for life an appointment to the Supreme Court, or just an appointment to the federal judiciary?
That's an interesting source of controversy, because currently there are proposals to potentially make a Supreme Court term limited to 18 years, and then to ensure that a justice has a lifetime appointment, that justice would return to the Little League, as after 18 years might return to a circuit court, an intermediate court of appeals. Whether that's constitutional or not is subject to current debate.
Okay. Now, Andy called this the least dangerous branch and told us that it's described third in the Constitution after the legislative and executive branches. Let's talk a little bit about how people get to the Supreme Court. Are there any requirements, prerequisites? Can any of us apply for the job? What's it look like there?
You mean how you get a job on the court, or how you get a case before the court?
No, let's talk about who are the justices first. So right now, I think every one of the justices went to law school and is a lawyer. But is that strictly a requirement?
Yeah, the Constitution doesn't spell out any prerequisites of that sort. One does not have to be a lawyer. The president has to nominate you, and the Senate has to agree to put you on the court. And as long as those two things happen, then you are on the court.
So the Constitution does prescribe minimum ages for service in the House of Representatives, the United States Senate, and to be president. But there's no minimum age or any other qualification for the job of Justice of the Supreme Court. Is that right?
Any of us could apply. That's right.
That's right. Although people don't ordinarily apply, I suppose. Okay. All right. So in my correspondence with you before the program began, I said I thought many of in the audience would be like me, no training in the law. What we know of the law is from television programs, and what we see in television programs are criminal trials. Witnesses, a defense attorney, a prosecuting attorney, evidence, witnesses being interrogated, and so on. Tell us how the proceedings in the Supreme Court differ from that picture that we have from the legal dramas on television. If I go into the Supreme Court while it's in session, what am I going to see?
Tim, you want to take that?
Well, sure. Well, what you're going to see is at what we often have in appellate courts, and they don't have juries, they don't have witnesses and things of that nature. It's basically you'll have attorneys for each side arguing on behalf of the parties, and the justices or judges, if it's at a court of appeals level, will interrupt on a regular basis as the attorneys are trying to present their case in a very limited fashion. Usually it's maybe 15 minutes, sometimes half an hour, maybe sometimes even an hour, depending on the type of case. And then, as I say, if it's a U.S. Supreme Court, the justices will be asking them questions of various sorts that they probably thought of beforehand, having read the briefs. And then basically it's over in about an hour or so. And at that point, the justices will go back and give it their thought, and eventually a few days later vote on which way they want the case to go.
Okay. And let's talk about what kinds of cases get to the Supreme Court, how they get there. So I have a complaint about I had a friend who was a federal judge, and he said in his youth, everybody responded to a minor annoyance by saying there ought to be a law. And that now today they say, well, that's unconstitutional. We've elevated the the status of our complaints in that way. So tell us a little bit about what kinds of cases the court considers and how those cases get to the Supreme Court. Maybe how much competition there is to get a case to the attention of the Supreme Court.
Yeah, the Supreme Court is different from many other courts in that it picks which cases it hears. It doesn't have to decide every issue that comes through the door. For the most part, the bulk of its docket is resolving differences that have arisen between the circuit courts. The Supreme Court wants a uniform federal law across the country. And if an appellate court in California says one thing and a court in New York says a different thing, then it's the Supreme Court's job to resolve that so-called conflict.
Mm-hmm.
The Supreme Court might also get involved in the relatively rare circumstances when a court holds a federal statute unconstitutional. Setting aside the legislature's law is a very severe and major exercise of judicial power. And in that circumstance, the court might be more likely to grant cert, as they say, and decide to hear the case.
Okay. All right. So let's think where we want.
If I could follow up on that just a little bit, basically back on terms of what your friend was saying, what I think that also demonstrates is the increasing importance of, in particular, the U.S. Supreme Court and our political system. That before the legislature, the one that was known for passing the laws, and of course the executive, the president, would have to sign them. But when we saw, particularly in the 30s, 40s, and into the 50s, that there seemed to be more reliance on the Supreme Court and the courts in general to declare laws unconstitutional or to advance the law in various ways, whether it's declaring a right of privacy or declaring discrimination to be unconstitutional, violation of equal protection, things of that nature. And that's why your friend probably says this today. They say, oh, it has to be unconstitutional. Again, demonstrating perhaps that additional reliance on the courts for making laws.
Okay.
The one other thing there that might be worth noting, Leon, is that there are, as Andy said, you have to ask the court to agree to hear your case. And there are many, many thousands of such requests every year. And the Supreme Court can decide how many of them it's going to take. Right now, it takes 60, 70, maybe 80 cases. And so as a frustrated President Trump said recently when talking about the difficulty of getting a case in front of the Supreme Court, it's difficult for him, perhaps more difficult than he'd like. It's difficult for anybody because, as Andy said at the outset, they have almost total control over their docket.
Okay. All right. So in sharing that phrase, it ought to be, that's unconstitutional rather than there ought to be a law. I wonder, do you agree with me that the public's expectations of the Supreme Court have changed during our lifetimes as well? Do you think that's the case, that there's a public understanding of the role of the court has changed over the course of, let's say, the second half of the 20th century or something like that?
I think in recent years, there's been stability in the court's role. But if you look to the beginning, maybe something to keep in mind is that the Supreme Court didn't even have its own building until the 1900s. The idea that it could easily set aside congressional enactments the way that arguably does today wouldn't be supported. So within the first 50 or 60 years of the court's history, it only declared 2 statutes unconstitutional. Whereas, the trend in the last 30, 40, 50 years is for the Supreme Court to more routinely set aside an act of Congress. And that is a new development if we look at the entire arc of the Supreme Court's history.
Okay, I'm going to share some of my ignorance or newfound knowledge in the hopes that this will stimulate some conversation as well. As I say, I'm the only one here who comes as an amateur to this subject. And I've only learned kind of late in life, I learned that the Bill of Rights did not apply to the states until relatively recently in our country's history. So this is called the incorporation of the Bill of Rights. Is a kind of 20th century phenomenon. And then I learned this, in reading a little bit about the New Deal, that in my parents' youth, laws that mandated a minimum wage were deemed unconstitutional, that the constitutionality of the Social Security Act was contested, and so on. And I think that's probably a perspective that's not very familiar to many Americans. Does anybody want to say something about that?
I'll take the first of those, have to do with the Bill of Rights, and then someone else can pick up the second. But when we created the Constitution, when those young states decided to ratify the Constitution, they weren't worried about state governments. They didn't create the Constitution because they saw state governments as a problem. Rather, the Constitution was all about creating the federal government and defining what its role was going to be. And there was great anxiety about whether this newly created federal government and all the new federal officers, like from a president to members of Congress and so forth, ways in which they might abuse their power and, if you will, kind of become a replacement for King George III, in many instances, a geographically distant, powerful official who's going to abuse you from afar. And so the Bill of Rights was quickly added to the Constitution in order to place some limits on the federal government. And it wasn't until after the Civil War, we get the 14th Amendment, which has some of the Constitution's most famous language, an equal protection clause, also a due process clause. And through some kind of doctrinal complexities that probably would take us further into the weeds than you might want to go, in the 1900s, the Supreme Court started looking at some of that language in the 14th Amendment's due process clause, specifically its use of the word liberty. And if you look up the 14th Amendment, folks will find the word liberty there. And the court found that that term liberty kind of incorporates by reference many of the provisions of the Bill of Rights. Not all of them, but almost all of them have been deemed now to be incorporated in that term. And as a result, again, I'm kind of glossing quickly over some over the weeds here, but as a result, most of those provisions of the Bill of Rights now apply to state government officials and to local government officials, just as much as they do to federal officials.
Okay. Anybody else on that topic?
Well, I'll just add that with respect to issues that are contested, which might seem quaint today, that relates a lot to the so-called Commerce Clause. Early in our nation's history, it was debated whether Congress could create a bank, a federal bank. It was debated even whether Congress could appropriate money for the building of highways or railroads or normal roads. I guess back then we didn't have Interstate 80 in the early 1800s. But in any event, over time, the Supreme Court has interpreted the so-called Commerce Clause within the Constitution broadly, such that things that might have created a fight 100, 150 years ago are now almost universally acknowledged to be within Congress's power. So we don't fight over whether the Social Security Act is constitutional or not any longer.
But we did fight over the Affordable Care Act 10 years ago. And as I recall, a reporter asked the Speaker of the House, Nancy Pelosi, what part of the Constitution gives Congress the power to make people buy health insurance? And she looked bewildered or amused or dismissed the question. And ultimately, the Supreme Court had something to say about that. So I think, what's your opinion of the public's understanding of what limitations the Constitution puts on Congress?
Well, let me go ahead and talk a little bit about this. You know, it's not entirely clear that the public would have that kind of understanding, because to a certain extent it gets into, as was said, into the weeds to a certain extent in terms of the legal doctrines and, you know, whether you're talking about the Commerce Clause and what's possible and so on and so forth. From a public point of view, we perhaps sometimes just boil it down to who's a liberal and who's a conservative. And although that doesn't always work, it tends to work fairly often. And one of the things that we noticed until recently was, well, and actually this is true all the time, is who's the middle justice? Who's the justice that ideologically is the middle of the nine? Because if you have that person making a decision, and again, if it tends to be a fairly ideological type of case, then you'll have a 5-4 decision, as opposed to decisions that might be 9-0 or 8-1 or some other combination. And up until recently, that middle justice was Anthony Kennedy. And so usually court watchers would say, okay, what will Kennedy do? Now it seems to be perhaps Justice Roberts. Now, again, it wasn't always Kennedy that was in the middle. And in fact, you mentioned the Obamacare case. It was actually Roberts was the one that joined the liberal wing of the court to uphold its constitutionality. And so that's how it always. Now, those of more tension, you know, political, going to look at more specific issues, and, you know, again, whether it's commerce doctrine or something of that nature. But for the public at large, it may be that it just boils down to who's a liberal and who's a conservative, and are they voting that way in this case?
Okay. Well, let's talk about what divides the country on the Supreme Court then. We've had some contentious hearings to confirm nominees to the Supreme Court. I think of three in particular over the last 30 or so years. Robert Bork was not confirmed, Clarence Thomas, Brett Kavanaugh a couple of years ago, and so on. Tell us the history of that. Have these hearings become more contentious? Has this become a more hard-fought issue to put somebody on the Supreme Court?
I think that's absolutely the case. The late Justice Ginsburg, around the time of Justice Kavanaugh's confirmation, remarked that I wish things were as they used to be, as opposed to as they are now. Justice Ginsburg, I believe, was confirmed unanimously, or maybe near unanimously, and it's unimaginable that a Justice Ginsburg clone today would receive such a vote. So things have become quite contentious over the last 20, 30 years.
Even the fact that we have these hearings, we didn't always have, the Senate Judiciary Committee did not always bring nominees to the Supreme Court before them for questioning or interrogation of any kind. And when that practice first started, it was kind of a polite occasion. It was very short, just kind of kind of an official public greeting, introduction, one to the other, but they didn't really serve much function beyond that. And then that has slowly changed to be the spectacle that we all know it to be now.
And I think that there are two things that sort of play into that. One I've already mentioned, which is the idea that we're putting more importance on the courts, that people will go to the court if they can't get something passed through a legislature. Like here in Iowa, it was a matter of getting same-sex marriage to be considered constitutional. That wasn't put up to a vote here. It was done through court decisions with the Iowa Supreme Court. The other thing that sort of plays into that was with the Bork hearing. It was really the first time that the hearings were televised, and that made them more important. The senators had to pay more attention. Then Senator Biden was running the Judiciary Committee at the time, and he was also running for president. So people were saying that, oh, this is a good opportunity for him to get some publicity and so forth for his early campaign. And so as a result, interest groups took more notice, and it became more of, as the word was said, more of a spectacle. And so there's a fight. And the fact that the court is now much more important means that ideological balance is important. And that's one of the reasons why we saw such a fight over the Amy Coney Barrett confirmation hearings.
Isn't it also the case that other elements of a political campaign have come into this, with fundraising, direct mail, direct appeals to the voters? This isn't an argument just among the senators now. It's an appeal for partisans throughout the nation to write letters, send in checks, and so on. Isn't that the case?
It was before my time, but my understanding is that at one point in American history, you could drive through a small town and see "Impeach Earl Warren" signs on the road, which presumably, I would guess, almost no one in 1830 knew who the Chief Justice of the United States was, but a very different perception of the court among the public today.
Well, that was very sneaky, having Earl Warren and Warren Burger. That one always confused me. Okay.
They were very different.
Okay, so if the two major political parties had their way, how would the court look different with one party versus another? Is there a simple way to understand what this means, liberal, conservative? Or maybe are you worried that when we report on decisions from the court now, we're attaching those words, just as we do with discussions in Congress, where we put an R or a D after the name? Now, when we report on a court decision, we are also telling you liberal or conservative, appointed by Clinton or Obama, or appointed by Bush or Trump, and like that. Anybody want to take a stab?
That is right up the center of the political science highway, I think. So I'm going to wait and see what Tim has to say.
Yeah, Tim, it's your job.
Yeah, well, the fact that people were unhappy or have been unhappy with the votes of various justices is nothing new. Justice William O. Douglas got into a lot of hot water with some of his votes. He was considered the most liberal justice of his time. And so, there were threats of impeachment over him too for some of his votes in various cases. But it's gotten to, again, a more intense time. We're at a more intensely partisan time, not just for the court, of course, but for the political parties and the political system in general. And of course, that filters into the court as well. One of the things, of course, that we're seeing right now is that because Democrats now are sort of on the, or I shouldn't say Democrats, liberals are in the minority on the Supreme Court, seemingly. You've got only 3 liberals, but you have at least 4 or 5 conservatives, maybe even 6. Roberts is kind of on the fence here a little bit at this point. But the Democrats are suggesting they want to add justices to the court. They want to change the structure in some particular way. Packing the court, as the term is usually referred to, that to put more justices on so that they have enough that are liberals that they can get their way on various votes. And of course, if Republicans take control, they would do then the same thing. I'm not sure Republicans, when they were unhappy in, say, the 60s when President Nixon was running, or then not president, but when Nixon was running for president in 68, of course, he was attacking the court and its ideological activism in the late 60s. But I'm not sure there were any calls for packing the court or changing the number of justices, just changing who they were, which, of course, he had an opportunity to do almost immediately.
Okay. On that point about what each party wants, I would be curious as to whether either party would truly want 9 of its clones on the Supreme Court. The reason for that is that the Supreme Court doesn't have an army. All it has is its public credibility. And if the court is perceived as being run by partisan concerns, and all 9 justices were uniformly appointed by the president of a single party, I do wonder whether public acceptance of their decisions would go down.
Okay, very good. So we're down to our last few minutes. So you might want to think about a parting message you want to offer to our audience. I want to thank you for joining us for this discussion, an important issue. We just came through one Supreme Court confirmation hearing and nomination, placement of a new person on the court, and it's in the news more and more. And as you pointed out, some of these justices are writing books. So I've read books by William O. Douglas and Robert Bork and I think others as well. Okay, so parting words for our audience, something they should, you'd like to see them learn more, or a concern, or just a thank you to our audience?
I'll make a quick quarantine-related pitch. It's usually quite hard to listen to the Supreme Court oral arguments. We get a transcript later that afternoon and then an audio recording later in the day. The court has been holding its oral arguments by telephone during this quarantine period. And so people can listen to them as they're happening. And the website, it's not a moneymaker, and I'm not involved with it anyway, but SCOTUS blog is the place to go. They do a terrific job of writing up plain English descriptions of the cases, and then you can listen to them be argued. I'd encourage people to get involved with watching the court do its work.
Very good. And I made a mistake there, giving Robert Bork a seat on the Supreme Court. That was just wishful thinking. Okay, so next, Tim, you want to say something to our audience in parting here?
Sure. Again, hopefully they learn more about the U.S. Supreme Court, if not today, on their own at other times. And I would say 2 things to watch for is to see once Biden is installed as president, if there's any additional movement to try to change the dynamics of the court, the number of justices, and also whether Justice Breyer might retire, especially depending on what happens in the runoff Senate elections in Georgia.
Okay. Andy, is it fair to say we have a pretty young court now, don't we?
That's a
No?
relative term.
Am I wrong? Well, we've got one person in her 40s and a couple in the 50s and 60s, right?
And a few above that.
Okay. All right. Words you'd like to say to our audience before we say goodnight?
We're talking quite a bit about division, but keep in mind that even though the Supreme Court hears essentially only the cases that divide everyone else, still about 1/3 to 1/2 of the time they are unanimous in disputes. So this idea of just 2 political parties hacking it out. That's not the case for much of the Supreme Court's work. That's just the case with those 5 or 6 decisions that we hear about at the end of the year that everyone gets interested in. But for the most part, the court does function in a collegial manner.
Okay. Thank you very much, all of you, for joining us on Ethical Perspectives on the News. Hope you can join us next time. Bye-bye.